Today we're going to be discussing a citation that the Illinois Department of Public Health recently issued to Windsor Estates Nursing Home in Country Club Hills after a resident there fell and suffered a brain bleed and broke his arm. My name is Barry Doyle. I'm a lawyer at Skokie, practicing nursing home abuse and neglect work throughout the state of Illinois. I'm also the author of Built to Fail, a free report available for download from my website, which spells out how the nursing home business model inevitably produces unnecessary injuries and deaths for nursing home residents. The resident who was involved in this particular incident was a new admit to this nursing home. He suffered from dementia and needed extensive assistance with standing and walking. This made the resident really a classic fall risk. When we look at which residents should be considered fall risk, two of the main factors that we consider are, does the resident suffer from some degree of dementia or confusion, and do they need some type of assistance with standing or walking, or do they have some type of balance or musculoskeletal dysfunction which places them at risk for falls. When you combine those two things together, these are nursing home residents who really truly are classic fall risks. They have problems maintaining their balance, and they can't be counted on to follow instructions or make good decisions for their own safety. Now, when this resident was admitted to the nursing home, he was assessed, and the assessment showed that he was in fact a fall risk. As a general proposition, once someone is recognized as being a fall risk, a fall prevention care plan should be put into place. Now, the fall that this resident experienced was 2 days after admission, and federal regulations technically require that the nursing home have in place an interim care plan within 48 hours of admission. It's not real clear from the text of the citation exactly when the resident was admitted to the nursing home and when the fall occurred, whether this was more than or less than 48 hours. But as a general proposition, when a fall risk assessment is done and the resident is shown to be a fall risk, that care plan is put into place right away. And the reason for that is that the basic promise that nursing homes make to families when they accept a resident in is that they will do the things that are necessary to assure the safety and well-being of the new resident. And if you have a resident in the facility who is recognized as being a fall risk, and you don't take reasonable steps in the form of putting together a care plan to help prevent falls, essentially what you're doing is gambling with the safety of the resident up until the point that that care plan is put into place and implemented. So in this particular situation, the resident was properly assessed as being a fall risk. The problem was that there was no fall prevention care plan put into place. The resident experienced an unwitnessed fall. The staff knew immediately after the fall occurred that he had fallen and hit his face. He bit through his lip. He was sent to the hospital where the diagnoses were made of the brain bleed and the fracture. So this is a situation where you had a serious injury suffered by this resident as a result of there not being a fall prevention care plan put into place. I hope you found this interesting. If you have any questions regarding this or any other issue involving nursing home abuse and neglect, please feel free to reach out to us. Our number is 312-263-1080, or we can be reached on the internet at www.accidentlawillinois.com. Thanks for watching.